I have a topic today that I could talk about all day long, and I've done this particular program a few times in an hour, and I have a lot less time today. So I'm going to run through a lot of things, and if anybody has any interest in this and has any questions, please don't hesitate to interrupt me and ask a question. If you're still here at this point, either you're honest and want to fill out your CLE form correctly, or you have some interest in the topic, or you're just dying to hear Doug when I get done. So I'll just push on and try to tell you a little bit about what I know about this topic. In our practice, we don't have a single case really that does not involve expert testimony, and that's getting to be the case more and more. So we know in order to pursue a case, we're going to have expert issues. And the question now has become, how do you do that, and how do you get your expert in, and what can they really say? The basis for admitting expert testimony comes from the Federal Rule 702. If you're dealing with an expert and you want to know whether you have a question with admissibility or you're concerned that your opponent's expert has issues, just start with reading the rule. Basically, the testimony has to be based on sufficient facts or data, and that comes from the facts in the case as well as the data that an expert uses to formulate an opinion. Those are separate things. The testimony is a product of reliable principles and methods, and the witness has applied the principles and methods reliably to the facts of the case. That's it in a nutshell. I don't know how many people here practice in federal court. All of the Daubert analysis is going to be heavily weighted towards federal law, but if you're in state court, the rules are exactly the same. Because in 2005, we got the new expert rule, that just tracks the federal rule, so it is the same. The three fundamental requirements are simply that the expert is qualified, and that the expert is applying a proper methodology, and that what the expert says is going to help the trier of fact. And that's an important part of it, because the expert can't just come in and offer an opinion on something that is not an issue in the case. That doesn't help the trier of fact. And if the expert is not utilizing proper data and facts based on the case, that confuses the jury, and that's not helpful. If it's a matter that the jury can decide on their own, an expert doesn't assist the trier of fact. It just somehow is an effort to bolster the position of the parties, and that is not a proper means of using expert testimony. What has happened with the whole Daubert analysis is sort of upside down. Because the question is, or the problem that expert testimony how it has evolved is, if it is improperly admitted, then we're at risk of the jury considering what has been called junk science. Unfortunately, there's not really the same discussion about the opposite, which is the problem when you don't allow expert testimony. We're going to talk about how the courts do not consider the admission and the exclusion in the same way. The problem that it creates for a plaintiff's lawyer is that if you do not have expert testimony, then you don't often have a case. So we have to look at the basics in talking about what you need to do to get an expert admitted. And for that, we look at the Supreme Court case law. There are 4 principal decisions that govern the admissibility of expert testimony out of the Supreme Court. And my husband and I affectionately refer to those decisions as the 4 horsemen of the apocalypse, because they've wreaked havoc on us all, and we're going to talk about them individually. And these are cases that have, obviously, Daubert started back in 1993, and you probably all heard about this ad nauseum, but it is still these 4 cases that, and primarily the first 3, are going to govern every single decision on the admissibility of expert testimony. A really good decision came out of the First Circuit last Wednesday, the Millward versus Acuity Specialty Products case, and the beginning of the analysis on the admissibility of the expert discussed Daubert Joyner, and Kumho-Tyre. Every single case is going to do that. So if you are curious about it or you have an expert issue and you've never had one before, read the cases. And there are thousands of cases that have interpreted these cases. There are probably thousands of law review articles that have discussed these cases. But start at the basics. Again, going back to Georgia law and why we care about these cases out of the Supreme Court and federal rules and federal law, the Georgia legislature specifically said that in considering the admissibility of expert testimony in Georgia state court cases, the courts are supposed to consider basically excluding any expert testimony that would not be allowed in any other court. That's a pretty strict bar to get over, and that the Georgia courts are to look to Daubert, Joyner, and Kumho-Tyre for guidance. So Daubert was the first case, and just in general, the courts, the trial judge is supposed to look at the expert's testimony, the basis for that testimony, to determine if it is scientifically reliable. And there are 4 non-exclusive factors. Consider the falsifiability, whether the opinion and the basis of the opinion has been subject to peer review, whether the evidence has been shown to have a known error rate, and whether the methodology is generally and the type of opinion is generally accepted in the area. Daubert did not produce a rule to follow. It does not have a checklist. It just says these are the things that courts are to consider. And the assumption is that judges are going to be able to do that. That's a pretty big assumption. When Daubert was first decided, it was clearly, or the idea was supposedly to make the admissibility of testimony more lenient and more flexible. When it first came out, the reports were actually that the plaintiffs had won this case. I didn't feel that way, and very quickly we learned that that was not the case, because the way Daubert has been used has been to exclude testimony more than to permit it. As a result of the Daubert decision, first, before plaintiffs, but defendants started filing Daubert motions. And that was done in the Joyner versus General Electric case, like in many others. And what happened with the Joyner case is probably more problematic than what Daubert did, and that is the standard of review that's come out. And when a judge makes a decision on a Daubert motion or the 702 ruling on the admission of expert testimony, it is reviewed for an abuse of discretion. And we all know that, but the consequences of that is pretty severe, because if a judge wants to get rid of a case, he can use a Daubert motion to get rid of a case, and it's not the summary judgment standard, it's the abuse of discretion on an evidentiary ruling. So the only thing standing between you and getting your case to a jury is a judge, and so the judge is the be-all, end-all. You need to know your judge. You need to know how to appeal to your judge's intellect and the things that he or she finds important in these areas, and tailor your motions either to strike or in defense of your expert to that judge. And one of the most important things I can tell you today as a plaintiff's lawyer in dealing with Daubert is that you have to separate, because of that standard of review, you have to separate the evidentiary ruling on the admissibility of the expert and any summary judgment motion. Now, what happened in Joyner and what happens in many, many cases every single day is that you get the 1-2 punch, and the motion for summary judgment is filed with the Daubert motion, and when the expert is excluded under Daubert, expert or experts, the summary judgment has to be granted because there's no evidence left, because you have to have your expert testimony, and so that's a foregone conclusion. So you have no case to proceed with. Kumho, of course, talked about expanding. Daubert was a very scientific case dealing with epidemiology and the like. But we know that we use experts in everyday things, in car wrecks, and we could have somebody that is a trucking expert that didn't get past the 10th grade, but is an expert in mechanics. And that person is subject to the same analysis, and that's what Kumho Tyer said. So in any case where you have somebody who has a specialized knowledge, even if it isn't scientific per se, you have to go through this exercise. Weissgram was the fourth case in this series. And what Weissgram, the nugget out of Weissgram is that you have to be prepared for a challenge at any time, and that you have to know that you have Daubert-proof experts all the way through your trial. What happened in Weissgram is the plaintiff actually won that case and got a verdict, and it went up on appeal, and the appellate court said, well, I disagree with we disagree with the admission of the experts, and therefore we're going to sua sponte grant a directed verdict because having now reversed the admission of the expert, there is no proof, and the case is over. So the nugget out of that is that you need to know that you have to have good experts and have backup experts if need be, and that's before that point in time. The judge does basically now much of what the jury is supposed to do. So we were talking about voir dire and the importance of these 12 people or 6 or 8 people or however many you have on your panel. In a Daubert situation, you have to win your case over with just this one person because the judge is charged with that duty. One of the things that you need to know is that the judge cannot decline to exercise this discretion. They have to go through the exercise. So if you're making a challenge, they are required to hear your case and do that. They cannot punt. As I said, the standard review is really the problem, and I've given a lot of thought to what that means, and it sort of goes along with that. The judge can't punt. In order to exercise discretion, they have to exercise discretion. So this is a quote I actually found out of the Millward case, which just came out last week, that says that the abuse of discretion standard is not monolithic. Within it, embedded findings of fact are reviewed for clear error, questions of law are reviewed de novo, and then the judgment calls are subjected to the classic abuse of discretion review. So look within and behind all of the things that the judge is supposed to do in doing a Daubert analysis, and if the judge hasn't followed the judge's methodology, then that can be attacked on an easier standard than just abuse of discretion. This is a quote that I often quote when I'm doing a Daubert motion to strike someone else, is that the object of Daubert is to make certain that an expert, whether basing testimony on professional studies or personal experience, employs in the courtroom the same level of intellectual rigor that characterizes the practice in the relevant field. And that's really what it's all about. Come in there and tell us real science. You just didn't pull this out of the air. It just has to be the kind of thing that you would go to your colleagues and say, I will subject this to your analysis. And if it passes that kind of evaluation, it's the kind of thing that the jury should be allowed to hear. But with that in mind, and along the same lines, if you're defending a Daubert motion, it is not meant to just be so rigid that you can't cross-examine on it. You still have the ability to go to court and to say, I can attack this. This can be attacked on cross-examination. If the methodology is right, even if you don't like the conclusion, that's for the jury to hear at trial. One of the things I wanted to mention is that there's an increasing trend by defense teams to file Daubert motions very, very early, especially in complex cases. And they're basically converting the whole Daubert evidentiary ruling into a motion to dismiss, and then there's sort of a mini trial on the expert analysis, and before you really even get into the case, you find yourself out. And I put in here a site if you're interested in looking at this. I don't have time to get into too much about how the court analyzed this, but it's the tissue product liability litigation case where this was done, and it is being done more and more, and how the court handled that and what to be looking out for if you have that kind of issue. Another issue that's unique to Georgia, at least our evidentiary rules, is that the affidavit requirement in a professional liability case the expert in the affidavit must satisfy the 702 analysis. And that sort of goes without saying, but one of the interesting things about that is that if there is a motion to dismiss filed based on the affidavit and there's consideration of the expert's background, that is going to be reviewed for an abuse of discretion. But if it's just the normal 911 9.1 defense motion, it's subject to a de novo review. So it's nonsensical, but that's what happens. So this is what happens later on. Once you get into the evidence, your expert can be challenged and you can be thrown out of court because the affidavit expert was not good, even if everything else is fleshed out well. With respect to the difference between federal and state courts, federal courts are much more accustomed to using these and to seeing these motions, although state court judges are more and more frequently dealing with them. My very cursory study of this is indicated that the state court judges don't really like them. They do not like them filed in a perfunctory fashion, although it's pretty standard that it's done that way in federal courts. Again, I have a lot of things in here that are probably a little too esoteric for our purposes today. I did want to mention the double standard in Daubert, and I have a lot of this in the paper that I'm not going to get into, but just keep in mind that if you're a plaintiff in a case, your expert is going to be scrutinized much more heavily than the defense expert. Part of this is because we have to have the expert to go forward, and so if we don't have the expert, then that's the end of it. We might not even get to the defense expert. But the court's handling of motions, of Daubert motions, they're more inclined to strike a plaintiff's expert. They're more inclined, the appellate courts are more inclined to reverse the admission of a plaintiff's expert, and they're more inclined to reverse the exclusion of a defense expert. It's just the sad reality. And the Daubert cocktail, this motion for summary judgment, Daubert 1-2 punch, is obviously something that affects only the plaintiffs. Because of Daubert and the requirements, what we have to do to get our experts in, and the fact that we have to have the experts, it's made a lot of cases so expensive that you just can't pursue them. They're very expensive to get an expert to do what they need to do to be Daubert proof. You have to pay a lot of hours of work for them at federal court for them to do their reports, in either system to defend their opinions in deposition and in court and in many hearings, so that many cases are just not, you just can't proceed with that kind of cost involved. All experts are subject to challenge, you know, like I said, the trucking expert on up to the very complex medical epidemiological type expert. But causation experts are certainly most likely going to be subject to a challenge and most likely going to be struck on Daubert grounds. But we're seeing more and more damages type experts also being challenged. And I put in here a PricewaterhouseCoopers study on financial experts. I'm not going to get into it, but if anyone's interested, it's a great study, analysis of how the different circuits have handled motions and who gets struck and what the bases are for that particular discipline. And there's a couple of graphs I have here that just show, it's interesting that the First Circuit is the least likely to get a Daubert motion granted, and that is the circuit where this great opinion came out last week. So it really depends on where you are. 11th Circuit, we're kind of in the middle. And this is a graph that just shows the outcome of Daubert challenges overall, how many are granted, denied, or partially granted, and some that where there has been no decision at all. Defense lawyers, really, they like to file these, if for no other reason that it's a complex motion, and you get bill a lot, and there's really no harm in doing it. You don't get chastised by the court for filing a frivolous motion. They should, but they're not. So they just like filing them. Huh? 3 minutes? Oh, I'm about a quarter of the way through. Let me just get to the good stuff about how to use them. We file Daubert motions a lot, and I think you should, because defense lawyers do not always hire good experts. In fact, sometimes they hire really, really bad experts. And in a malpractice case, you can even file one against the defendant himself. He can't testify if he's not qualified and he hasn't followed the proper methodology. So go ahead and file them. But remember, if you file one, you have to, live by the sword, die by the sword. If you say this is what you need to do, you better be darn sure your experts have done that well as well. And one of the reasons to file them, quite honestly, is that they're coming at you. So file them against the defense, and at worst, maybe the judge will just say, look, I'm going to let everybody's in. So at least you get to salvage yours, because the most important thing is that you maintain your motions. You need to go ahead and protect the record. It is an evidentiary ruling, so if you file the motion, you've made the motion, it's in there. A couple things just about getting a Daubert-proof expert. In my view, it is unacceptable to retain an expert that's not qualified. The issues in Daubert motions should be, was the proper methodology followed? You shouldn't get an expert struck because he's not qualified. That's crazy. But there are parts of an expert's testimony that might be okay and parts that need to be excluded. You're not necessarily striking the expert, you're striking the opinion. So there's some nuances there. So they might be qualified to say one thing but not another, and they might have applied the proper methodology on one area and not the other. So it's not a black and white situation. Help your experts write their Rule 26 reports. Under the new rules, all of that is protected, so you can have drafts going back and forth. In federal court, the Rule 26 report is everything, so do it right. Make sure everything that you need to survive a Daubert challenge is in the Rule 26 report. And by the same token, read that report that's filed by the defense experts and go after them for the parts that are not appropriate. We've had experts struck simply because their case lists are not adequate. Under Rule 26, they are supposed to tell you all of the testimony that they've given in the previous 4 years, deposition or trial. I've given 2 examples here. This first one says not a whole lot. You're supposed to be able to find the testimony. So it needs to at least have the court, which party you're for, that type of thing. The second one is a much more helpful deposition list. So we've been successful in going to the court and saying, look, they have not satisfied Rule 26, and the judges will at least tell them to go back and do it right and give you an opportunity to find this prior testimony that can be really, really helpful in getting them struck. And I'm done, right? If you're really in a scientific type analysis, we call this the Bible, the reference manual on scientific evidence, get that, know that, and use that in your analysis. And if you do it right, you'll both be able to protect your expert from the challenge and perhaps get the other side not to have one at all. So, thank you.
Thank you all.